You are sitting in your car on the side of a two-lane road. It is 9:30 on a Tuesday night. You were driving the speed limit. You used your turn signal. You did absolutely nothing wrong. But there are red and blue lights flashing behind you, and an officer is standing at your window with a flashlight pointed at your face. You handed over your license and registration. You were polite. You did everything right. And then the officer says 6 words that change everything. I need you to step out of the car. Your heart rate doubles. Your palms go slick on the steering wheel. Every instinct in your body is screaming that something just went very wrong. And you are right. Something did just change. But it is not what you think. What you do in the next 15 seconds will determine whether this stays a routine traffic stop or becomes the worst night of your year, and almost everyone gets it wrong. I am attorney James Wakefield. I spent 8 years prosecuting cases before I switched sides. I have been a criminal defense attorney for over 20 years now. I have watched hundreds of hours of body cam footage where a simple traffic stop turned into an arrest, and I can tell you with absolute certainty that in most of those cases the person was not arrested because of what the officer found. They were arrested because of what they said and did after the officer told them to step out. Today I am giving you the exact words to say, step by step, level by level, so that no matter how far this encounter escalates, you know precisely how to protect yourself. Now, before I go any further, laws vary by state. What I am sharing today applies in most jurisdictions across the United States, but you should always verify your local laws. That said, your constitutional rights are your constitutional rights everywhere. The Fourth Amendment does not stop at a state line. The Fifth Amendment does not take a night off. So let us get into it. Here is what most people do wrong, and I mean almost everybody. The first mistake is the most common one I see. The officer says step out of the car and the driver says why. Just that one word. Why? It sounds reasonable. You are confused. You are not doing anything wrong. But here is what the officer writes in the report. Subject became argumentative and refused to comply with a lawful order. Those 14 words turn you from a cooperative citizen into a problem. And everything that happens after that gets viewed through the lens of your refusal. The Supreme Court ruled in Pennsylvania v. Mims back in 1977 that an officer can order you out of the vehicle during any lawful traffic stop. Any traffic stop. They do not need to suspect you of a crime. They do not need to explain why. They can simply order you out for officer safety. That is settled law. So when you ask why, you are not exercising a right. You are giving them a reason to write you up as uncooperative. The second mistake is even worse. Some people here step out of the car and they start talking. They start explaining. They say things like, "Officer, I have not done anything wrong," or "I was only going 5 over," or "I just left my friend's house, I only had 1 drink." I had a client 2 years ago who said those exact words. I only had 1 drink. She was coming home from a book club. She had a single glass of wine 4 hours earlier. She was stone cold sober. But the officer wrote, subject admitted to consuming alcohol prior to driving. That single sentence gave them probable cause to request field sobriety tests. She failed the walk and turn test because she was wearing heels on gravel at 11 at night. She was arrested. She spent 9 hours in a holding cell. Her case took 14 months to resolve. It cost her over $12,000 in legal fees. All because of 6 words. I only had 1 drink. You cannot unsay something. Once it is on body cam, it is evidence. The third mistake is physical. People reach for things. They lean toward the glove box to grab paperwork. They reach into their pocket for their phone. They turn around too quickly. Every sudden movement when an officer has asked you to step out is interpreted as a potential threat. Officers are trained to treat traffic stops as one of the most dangerous parts of their job, and they are not wrong about that statistically. But that training means your sudden reach toward the center console looks the same to them whether you are grabbing your insurance card or grabbing something dangerous. Do not give them a reason to escalate. Hands visible, movements slow, mouth closed. The fourth mistake is the one that breaks my heart as a defense attorney. People consent to things without realizing it. The officer says step out of the car, and the driver steps out and just stands there. The officer says, "Mind if I take a look inside your vehicle?" And the driver shrugs and says, "Sure, go ahead." That shrug just waived your Fourth Amendment right against unreasonable search and seizure. That is the right that says the government cannot search your property without a warrant, your consent, or probable cause. When you say "sure, go ahead," you just handed them consent. And consent searches are almost impossible to challenge in court. I have seen cases thrown out because of an illegal search. I have almost never seen a case thrown out when the defendant said go ahead. Have you ever said something like that to an officer during a stop? Something you thought was just being polite but was actually giving away a right you did not know you had? You are not alone. That is exactly what I am here to fix. So here is level 1. The officer has just said, step out of the car. Here is exactly what you do and exactly what you say. First, the physical part. You comply. Immediately. You do not hesitate. You do not ask why. You open the door slowly. You keep your hands where the officer can see them at all times. You step out and you move to the rear of your vehicle on the side away from traffic. You use the car as a barrier between you and the road. You face the officer. You keep your hands at your sides or in front of you, open and visible. Do not put them in your pockets. Do not cross your arms. Do not lean on the car like this is casual. Stand still and stand calm. Now the verbal part. Here is exactly what you say. You say, Officer, I am stepping out as you have requested. I do not consent to any searches. Am I free to go, or am I being detained? Those exact words. Memorize them tonight. Say them out loud right now if you can. Officer, I am stepping out as you have requested. I do not consent to any searches. Am I free to go, or am I being detained? That sentence does 4 things, and every single one of them matters in court. First, the phrase, I am stepping out as you have requested, establishes on the body cam recording that you are complying. Nobody can claim you resisted. Nobody can claim you were argumentative. You acknowledged the order and you followed it. Second, I do not consent to any searches is the most important sentence you will say during any police encounter in your life. It invokes your Fourth Amendment right clearly and unambiguously. If the officer searches your car after you say those words and they do not have probable cause or a warrant, everything they find can be suppressed. That is the fruit of the poisonous tree doctrine. Evidence obtained from an illegal search cannot be used against you. But that doctrine only protects you if you clearly stated that you did not consent. If you said nothing, or if you shrugged, or if you stepped aside, a prosecutor will argue you gave implied consent. I know because I used to be that prosecutor. Third, the question, am I free to go, or am I being detained, forces the officer to define the encounter. This matters enormously. If you are free to go, the stop is over. Walk back to your car and drive away. If you are being detained, the officer must have reasonable suspicion that you committed or are committing a crime. That is a legal standard, and everything after that point gets scrutinized by a judge. Fourth, all of this is being recorded. Body cam footage is the single most powerful piece of evidence in a modern courtroom. When you speak clearly and calmly and state your rights on camera, you are building your defense in real time. Every word you say is being preserved. Make sure the words are the right ones. Has an officer ever asked you to step out of the car? Think about what you said. Think about what you did with your hands. Think about whether you accidentally consented to something without realizing it. Now you know better. But what if the officer does not accept that? What if they push back? Because they will. And this is where most people crumble. Here is level 2. You said your script, you were calm, you were polite, you were perfect. And the officer says something like this. Look, I am just trying to help you out here. If you have nothing to hide, this will only take a minute. I just want to take a quick look in the car and we can get you on your way. That sounds reasonable. It is not reasonable. It is a tactic. I watched officers use this exact approach hundreds of times when I was a prosecutor. It is called a consent request, and it is designed to make you feel like refusing is suspicious, like only a guilty person would say no. That is the entire point. They are trained to make cooperation feel like the only rational choice. Here is the truth. Saying no to a search is not suspicious. It is constitutional. The Fourth Amendment exists specifically so that you can say no. And here is something most people do not realize. If an officer is asking for your permission to search, that usually means they do not have probable cause to search without it. If they had probable cause, they would not be asking. They would be searching. The fact that they are asking is actually good news. It means the law is on your side right now. Do not give that advantage away. Here is exactly what you say. You say, Officer, I understand and I want to cooperate with all lawful orders, but I do not consent to any searches. Am I free to go? Say it calm. Say it polite. Do not raise your voice. Do not add anything. Do not explain why you are refusing. Do not say I have nothing to hide but, or I just do not think or my lawyer told me. Just the script. Nothing more. I want you to understand what happens when you say this on a body cam. The recording captures a calm, polite citizen complying with every lawful order while clearly asserting a constitutional right. If this case ever goes to court, that footage is gold. I have sat in courtrooms and watched judges suppress evidence because my client said these exact words on camera. Conversely, I have watched cases where the defendant said nothing and the prosecutor argued that silence plus stepping aside equaled implied consent. The judge agreed, silence is not enough. You must say the words. What the officer writes in the report matters too. When you say I do not consent to any searches clearly and on camera, the officer has to note that in their report. Subject stated they did not consent to a search. That one line in the report changes the entire legal analysis. Without it, the officer can write subject was cooperative and did not object to a search of the vehicle. See the difference? One sentence protects you. The absence of that sentence buries you. Now what if they push even harder? What if the friendly approach does not work and the officer changes tone? That is level 3. The officer might say something like this: Sir, I am going to need you to put your hands on the vehicle. I am going to conduct a search of your car. Or they might say, I am calling a K9 unit. Or they might say, based on what I am observing, I have probable cause to search this vehicle. This is the moment where fear takes over. This is where people either panic and start talking or they physically resist. Both of those reactions will destroy your case. I need you to understand something that goes against every instinct you have in this moment. If the officer is going to search your car anyway, let them. Do not physically resist. Do not block the door. Do not grab anything. Do not try to close the car door. Physical resistance during a traffic stop can get you charged with obstruction or resisting arrest. Those are separate charges that stick even if the original stop was completely unlawful. I have seen people beat the original charge and still go to jail for resisting. Here is exactly what you say, and I need you to burn these words into your memory. You say, Officer, I do not consent to this search. I am not resisting, but I do not consent. Say it once. Say it clearly. Then stop talking. Do not consent to this search, and I am not resisting, but I do not consent. That sentence is your legal shield. It preserves every challenge your attorney will later make. If the search turns out to be illegal, everything they find gets thrown out under the exclusionary rule. This is a recognized legal protection to ensure evidence is obtained lawfully. Evidence obtained through an unconstitutional search cannot be used against you at trial, but only if you preserved the objection, only if you said I do not consent on that body cam. While the search happens, stand where they tell you to stand. Keep your hands visible. Do not narrate what they are doing. Do not ask questions. Do not say that is not mine about anything they find. Especially do not say that is not mine. That phrase tells the prosecution you knew the item was there. Just stay silent. Your Fifth Amendment right to remain silent means you cannot be compelled to speak, and your silence cannot be used against you in court. The Supreme Court affirmed this in Miranda v. Arizona. But here is what most people do not know. You have to actually invoke it. After the court's ruling in Salinas v. Texas in 2013, simply staying quiet may not be enough. You need to say it, so if the officer asks you any questions at this point, you say I am invoking my Fifth Amendment right to remain silent, and I would like to speak with an attorney. Those words. Exactly those words. Now let us talk about level 4. The worst case. You did everything right. You complied with every lawful order, you stated your rights clearly, and the officer is putting you in handcuffs anyway. This is where most people fall apart, and I understand why. Being arrested is terrifying, but I need you to hear me on this. The arrest is not the end. It is the beginning of a legal process that you can win, but only if you do not give them ammunition right now in this moment on this roadside. Here is your protocol. Do not resist physically, not even a little, not pulling your arm away, not tensing up. Go limp and cooperative. Every movement you make while being handcuffed is being recorded and will be described in the arrest report. If you resist, the report will say subject resisted arrest and the officer used reasonable force to gain compliance. If you comply, the report says subject was taken into custody without incident. That second version is what I want to work with as your attorney. Say this and nothing else. I do not consent to any searches. I am invoking my right to remain silent. I want an attorney. Then close your mouth. I mean it. Seal it shut. Do not talk to other officers at the scene. Do not talk in the back of the squad car. Do not talk during booking. The microphones are on. The cameras are recording. Everything you say from this moment forward is potential evidence. I have reviewed cases where my clients were silent during the entire stop and then made one frustrated comment in the back of the patrol car that the prosecution played for the jury. One sentence. After 45 minutes of doing everything right, do not try to talk your way out of this. You will not convince the officer to let you go. That has never worked. Not once in my 20 years of doing this. What you will do is create a record that your attorney cannot fix. You will have your day in court. You will have a chance to challenge every single thing that happened during this stop, but only if the evidence against you is the officer's word and not your own. Now I want to give you one more tool. I call this the clean record phrase, and it is the phrase I wish every single client of mine had said before they called me. Here is the scenario most people do not think about. You have been pulled over. The officer asks you to step out. You comply. And then, instead of asking to search the car, the officer starts asking casual questions. Where are you coming from tonight? Where are you headed? Have you had anything to drink? What do you do for work? These questions feel conversational. They feel like small talk. They are not small talk. They are an investigation. Every answer you give is being mentally recorded and will appear in the officer's report. Where are you coming from tonight is not friendly curiosity. It is the officer looking for you to name a bar, a restaurant, a party, a friend's house where alcohol might have been present. Have you had anything to drink is not a yes or no question to the officer. It is a probable cause generator. Any answer other than a flat no gives them a foothold. The clean record phrase is this: Officer, I am choosing not to answer any questions tonight. I hope you understand. 14 words. Memorize them. They are polite. They are firm. They are unambiguous. And here is why this phrase is so powerful. It does not say I am not answering because I have something to hide. It does not say I refuse. It says I am choosing. That word matters. It frames your silence as a deliberate exercise of a right, not as evasion. And the phrase I hope you understand is not weakness. It is social de-escalation that prevents the officer from feeling personally challenged. I had a client 3 years ago who used almost this exact phrase during a DWI stop. She said, I would prefer not to answer questions tonight. The officer noted it in his report. Subject declined to answer questions. That was it. There was no probable cause for a breath test. No admission of drinking. No mention of where she was coming from. The case was dismissed at the preliminary hearing. The prosecutor had nothing to work with because my client had given them nothing to work with. Would you have known to say that before watching this? Most people would not. Let me pull this all together for you so you have your complete script ready to go. When the officer says, step out of the car, you step out immediately, hands visible, and say, Officer, I am stepping out as you have requested. I do not consent to any searches. Am I free to go or am I being detained? When the officer uses friendly pressure to get consent, you say, Officer, I understand and I want to cooperate with all lawful orders, but I do not consent to any searches. Am I free to go? When the officer searches anyway, you say, Officer, I do not consent to this search. I am not resisting, but I do not consent. When the officer asks you questions, you say, Officer, I am choosing not to answer any questions tonight. I hope you understand. When you are being arrested, you say, I do not consent to any searches. I am invoking my right to remain silent. I want an attorney. Then you stop talking. 5 levels, 5 scripts. Memorize them. Practice them in your car tonight. Say them out loud until they feel natural. Because when those red and blue lights appear in your mirror and your adrenaline spikes and the officer is standing over you with a flashlight, you will not think clearly. You will fall back on whatever is automatic. Make these words automatic. Now, everything I have covered today protects you during the stop itself. But what about when the officer says the 4 words that scare people even more than step out of the car? What about when they say you are under arrest and they start reading you your Miranda rights? Do you actually know what those rights mean and how to use them? Because most people do not. And what they get wrong about Miranda is costing them years of their lives. That is exactly what I am covering next. I am Attorney James Wakefield. Know your rights. Use your words. Everything I have shared today is general legal information based on current constitutional law and my experience as a criminal defense attorney. Laws vary by state. This is not legal advice for your specific situation. If you are facing charges, consult a licensed attorney in your jurisdiction. But knowing your rights before you need them, that is the smartest thing you can do.